In this unit, we're going to cover the display of your license. We're going to talk about dealer ethics, license suspensions and denials. We're going to talk about the disciplinary fine matrix. In the enforcement division, we're going to talk about dealer complaints, dealer insurance, retail contract bill of sale, odometer disclosure and tampering. We'll talk about sales to minors, dealer records and records inspections, and the Texas Department of Motor Vehicle Board. Remember, all Texas dealer licenses must be displayed prominently. This is a state law. When you receive your motor vehicle dealer's license, it must be displayed prominently. You do not place the license in a desk drawer or a file cabinet. You place it on the wall in your office. You worked very hard to gain your license, and you're going to be proud of it, and you need to display it where everyone can see it. If you ever have a surprise inspection from the Texas Department of Motor Vehicles enforcement personnel, they will verify that you have your license displayed conspicuously. Dealer ethics and integrity. It is imperative that you operate your business with complete integrity and the highest ethical standards at all times. You must follow every state and federal guideline on every transaction, period. If you don't operate strictly under all state and federal regulations, your dealer's license could result in suspension or revocation. Once you've had a dealer's license revoked, it is time-consuming and may be very costly, including legal fees for legal representation in order to obtain another dealer's license. Being completely honest with every one of your customers is a win-win situation. You'll really build your reputation your first few weeks in business, and you must build an ethical reputation. A good, positive selling experience with the customer will lead to more sales to the customer's friends, their coworkers, and their family. A bad, negative selling experience will result in customers leaving negative reviews of your dealership all over the internet. It's very easy for your customer to leave a negative review and comments on Google, Facebook, Twitter, and many other social media websites. When future customers see these reviews, they will not purchase vehicles from you. Customers want a dealer they can trust. To maintain your honest reputation, you must offer full disclosure on all vehicles before the sale. Always disclose every minor mechanical malfunction that you're aware of before the test drive. And by disclosing everything you know about a vehicle before the test drive, you're going to build an incredible reputation in your area. Unethical dealers can never discard a dishonest reputation. By operating your dealership with complete honesty and the highest ethical standards at all times, you will gain an honest reputation that will lead you to many, many more sales than that of a dishonest dealer. Being completely honest with your customers is a win-win situation. You will have the best reputation in your area, you're going to have the highest profits, and you're going to be in business for many, many years. Operating your dealership with complete integrity and 100% compliance equals more profits while ensuring your dealer's license will never be suspended or revoked. Let's talk about reasons for suspension or revocation of a used motor vehicle dealer's license. When you're granted a dealer's license, the state of Texas is giving you an opportunity to enter a business field that can be quite lucrative. However, you must follow several sets of rules and guidelines. All Texas motor vehicle dealers must follow the rules that we're discussing in this course, and the Texas Department of Motor Vehicles has zero tolerance for any dealer that does not follow the rules. Any dealer that does not comply or follow the rules can have their dealer's license suspended, revoked, or pay extensive fines. Let's talk about some of the reasons for suspension or revocation of a Texas motor vehicle dealer's license. And if you're following along in the manual, you can certainly read these with me. Falsifying or forging documents. A dealer may not falsify or forge a title document, including an affidavit making application for a certified copy of title. Filing a false or forged document. A dealer may not file a false or forged tax document, including a sales tax affidavit. Keeping open titles. A dealer may not fail to take assignment of any basic evidence of ownership, including a certificate of title or manufacturer certificate for a vehicle the dealer has acquired, which is known as an open title. Receiving, holding, or delivering an open title is a violation of the law and a very, very risky way to conduct business. An open title is kind of like a blank check, and we'll cover open titles extensively in our titling section here in just a little bit. Not assigning titles. A dealer may not fail to assign any basic evidence of ownership, including a certificate of title or manufacturer certificate for the vehicle the dealer sells. Misuse of plates or tags. A dealer may not use or permit the use of a metal dealer's license plate or a dealer's temporary cardboard tag on a vehicle that the dealer does not own or control or that is not in stock and offered for sale. We'll cover these requirements here in the dealer license metal plate section here in just a little bit. Making material misrepresentations on applications. If a person misrepresents a fact on any application to the department, whether it's a false statement of ownership, a false response to a felony question, or designation of a false place of business, a serious violation has occurred. Such violations could result at the minimum in denial of the application and possibly could result in civil penalties. Failure to maintain qualifications for your GDN, your dealer's license. The initial requirements to get a license must be maintained throughout the licensure period. And this includes all requirements as to signs, business hours, office requirements, phones, allotted spaces, leases, etc. The department may deny an application for a license, revoke or suspend an outstanding license, impose a civil penalty on a person whose license has been suspended, or for any of the reasons that are set forth in state law. The department shall cancel a dealer's GDN if the dealer obtains the number by submitting false or misleading information on the application. Refusal to provide evidence of being in business. A dealer may not fail to provide the department within 30 days after the date of a demand by the department satisfactory and reasonable evidence that the person is regularly and actively engaged in business as a wholesale or a retail dealer. Not remaining regularly and actively engaged in the business. Those people who are not really in the business as dealers normally carry a license for some other nefarious purpose. Maybe they just want a license to avoid paying sales tax on their personal vehicles, or possibly they want access to a dealer auction to buy vehicles at wholesale for personal use. Regardless, those persons who make fewer than 5 sales per year will have their license challenged. Texas law now requires tax appraisal districts to turn into the Texas Department of Motor Vehicles the names of any dealers who either fail to file the annual VIT declaration and monthly statements or do not sell 5 vehicles within the calendar year. We've got to sell at least 5 vehicles per year. Wholesale transactions will count towards your required 5 sales. Failing to report or pay taxes. Although the Texas Department of Motor Vehicles does not collect taxes, those dealers who fail to properly report and pay state sales taxes or vehicle inventory taxes could result in additional penalties and revocation of the license. Misuse of the license. Misuse of a license involves use of the license for purposes other than specifically contemplated under the dealer laws. Lending license numbers to an unlicensed entity to buy or sell vehicles, can't do that, or using the dealer location for illegal purposes. They are examples of misuse of a license. Off-site sales or curb stoning. Dealers are not allowed to sell vehicles from anywhere but their duly licensed premises, and that's according to TAC 2.215.136 of the Texas Administrative Code. Dealers are strictly prohibited from curb stoning, which is the practice of selling vehicles away from the dealer's licensed location. Dealers are also subject to penalty if they aid in and abet curb stoning by selling vehicles to persons who practice curb stoning. Failure to apply for a title within 30 working days of the date of the sale. The most common complaint received from consumers is they have not received their plates or their title to the vehicle within 30 working days of the purchase. There are really only 2 valid defenses for this violation. The first defense is if the consumer has misrepresented their credit history on a credit application. And, in that instance, the dealer has the right to rescind the contract. The second defense is if the dealer has promptly paid off the lien holder of the vehicle, but the lien holder has failed to issue a release of lien within 10 days of the payoff. And this is known as the lien holder excuse. A seller finance sale allows 45 calendar days to apply for title. Dealers are exempt from transferring title for certain vehicles based on vehicle weight. Giving the title work to the customer. Since 1996, dealers are required to apply for the title and registration and never give the paperwork to the consumers. The tax assessor collector offices have been very cooperative in turning in paperwork to the Texas Department of Motor Vehicles that has been filed by consumers who bought a vehicle from a dealer. The only exception to this rule is if a consumer is taking the vehicle out of the state immediately, then a dealer should have the consumer fill out the comptroller's sales tax exemption for certificate for vehicles taken out of state. This form is kept in the dealer's sales file in case of an audit, okay? So the dealer does have a certain amount of time to provide the buyer any necessary forms to register that in their state. Incomplete or no records. Rules require records to be kept at least 48 months. The current and immediately preceding 13 months must be available for inspection at the dealer's location. Records from the prior 35 months can be kept either on the license site or an off-site within the same county. Failure to keep records at all or complete records is a very serious violation. Not responding to requests for records. Not keeping records is a serious violation, but not producing those records when a representative appears at the dealership is even more serious. Most information is requested by the state through certified mail. If a dealer fails to respond to this mail request, it is a violation, and the agency representative may travel to the dealership to inspect not only the requested information, but the general state of records overall. Forgery or fraud. This encompasses rollbacks of an odometer, title fraud, fraudulent sales of reconditioned vehicles. Also in this category are credit fraud or commercial fraud, floor planner fraud, and consignment fraud, which usually go hand in hand with these activities. In all of these instances, the perpetrator has made representations that may have induced someone to buy a vehicle that he or she would not have purchased but for that fraudulent representation. Fraud is also cited when a dealer files a false tax or title document. Spot deliveries. This fraudulent practice consists of selling and delivering a consumer a car after signing a retail installment contract and then calling the consumer back into the dealership to sign a new contract with a higher interest, higher payments, or to put more money down. This practice happens a lot when a dealer wants to tie the consumer to a sale but is unable to verify the credit in a timely manner. Dehorsing. Dehorsing is done in conjunction with the spot delivery and occurs when the consumer refuses to sign a new contract and demands back their original trade-in. And then they're told the trade-in has already been sold, thus forcing him or her into a new contract for a vehicle of lesser value. Parking on the right-of-way. Dealers are specifically prohibited from parking or displaying vehicles on the right-of-way adjacent to their dealership premises unless the governing body having jurisdiction of the easement, right-of-way, or driveway expressly consents to that in writing. Use of right-of-way property that is part of the state highway system may only be authorized by a lease agreement entered with the Texas Department of Transportation. This permission is given very seldom due to the nature of the safety hazard involved in allowing cars to obstruct the view of oncoming traffic. If a dealer wishes to inquire as to written permission, the dealer should call the local Texas Department of Transportation office. Failing to settle civil penalties. One sure way to lose a license permanently is to refuse or neglect to pay any civil penalties assessed against a dealer by the department. Odometer tampering. Dealers are strictly prohibited from fraudulently tampering with an odometer to reduce the number of miles indicated on that instrument. This is a federal and state law with serious criminal penalties. Besides the criminal penalties, a person could be permanently denied a dealer license upon such conviction. Does not maintain established place of business. You have to maintain your established place of business during your entire licensure period. You can't just close your doors, a month after you have gotten your dealer's license. Use of false or deceptive advertising. We have a whole section on legal advertising later on in the course. Fail to notify the Texas Department of Motor Vehicles of license entity changes within 10 days. So if you ever change anything with your license, such as your business structure, maybe your business hours, phone numbers, things like that, you have to notify the Department of Motor Vehicles within 10 days. Fail to notify the Texas Department of Motor Vehicle of any ownership changes in 10 days, or maybe your mailing address within 10 days, you have to notify the Texas DMV at any time any changes are made to the dealership. Fails to maintain $25,000 dealer surety bond for your entire licensure period. So you have to have your dealer surety bond in effect your entire licensure period. Failure to file annual vehicle inventory tax, failure to file monthly tax, failure to sell 5 vehicles per year, premises violations, including dealer surety bond violations, filing false tax statements when transferring titles. For example, let's say a dealer sells a vehicle to a consumer for $4,000, but when they're doing the title transfer, it says the dealer sold the vehicle for $2,000. That's a big, big no-no. And you might have a customer ask you to write down a lower price than the actual selling price on the paperwork, and that is a big, big, big no-no. So you never ever want to do that. Reasons for denial of the initial Texas dealer license application. You can have your dealer's license application denied if you make false statements of material facts on the application. As I've said, you have to make sure that application is true and correct for not only you, but every single other person who is named on that license. If you've committed certain felonies, if you've committed a fraudulent act, that is a felony or misdemeanor act involving motor vehicles. If you have no place of business, obviously you have to have a place of business before you apply for your license. Does not have a working telephone. You do not have a display lot area. Display area is not physically separated from another business's parking. Always make sure that your display area is physically separated from any other neighboring business's customer parking, because the Department of Motor Vehicles does not want one of your neighboring businesses' customers accidentally parking on your display lot and then someone thinks that vehicle is for sale. That's confusion the state would like you to avoid. So they always want to make sure that you have physical separation between your display area and any other business parking. Business is not physically separated from another business. Dealers must follow every law, every rule, and every guideline in order to operate a successful and profitable dealership. Any dealer that does not operate completely within the law will face fines and or license suspension or revocation. The disciplinary fine matrix. Dealers that do not follow every law, rule, and guideline may face substantial financial penalties. Section 503.095 of the Texas Transportation Code allows for a civil penalty of up to $1,000 for each act in violation and for each day of continuing violations. Section 2301.801 of the Texas Occupations Code allows for a civil penalty of up to $10,000 for each violation and for each day of continuing violations of these codes. The Texas Occupations Code also sets forth standards for assessing penalties. So I want you to be very aware of that. Not running your dealership with 100% compliance can really be very, very expensive. The state may also revoke a license for any violation. The Texas Department of Motor Vehicles maintains what's called a disciplinary fine matrix that is intended to give dealers a general guideline for how the department determines the most appropriate sanction for the most common violations. The matrix does not contain all possible violations, nor does it limit the department from seeking sanctions outside the disciplinary matrix recommended low and high sanctions when circumstances do require. They're also going to consider aggravating and mitigating factors. In determining the amount of civil penalties to assess, the department will consider the following aggravating and mitigating factors. So they're going to be looking at the seriousness of the violation, including the nature, circumstances, extent, and gravity of any prohibited act, and the harm or potential harm to the safety of the public, the economic damage to the public caused by this violation. The history of previous violations will also be looked at, the amount necessary to deter a future violation. Any other matter that the justice may require, including history of violations of a similar nature, a number of violations that have occurred. Also, if there's an attempted concealment of violation or intentional, premeditated, or knowingly grossly negligent act constituting a violation as well. In determining whether revocation is appropriate, the department will also consider whether the licensee is unfit under standards that govern the occupation and whether the licensee has made material misrepresentation in any of information filed with the department, and whether the license willfully defrauded a customer as well. So in determining the amount of civil penalties to assess, the department will also determine whether the dealer has acknowledged wrongdoing and whether the dealer has willingly cooperated with the department, and if there are efforts to be made to correct the violation in any other matter that may require. And also they want to know the present value the dealer has presented to the community, basically. So the Texas Department of Motor Vehicle has what's called the fine matrix. And the fines for certain violations of state law are set into the matrix and written into the Texas Occupation Code and the Texas Administrative Code. And it clearly states the punishments for Texas motor vehicle dealers that violate the law. They have the low sanctions, which will normally set the minimum fine or punishment, and what's known as the high sanction, which will normally set the maximum fine or punishment. Depending on the circumstances for a specific case, the minimum and maximum penalties and fines can be changed dependent on the severity of the license violations. And here you see the Texas Department of Motor Vehicle Dealer Fine Matrix. As you can see, and there's several of them here, you can certainly look these over, and these have been printed in your manual as well. As you can see, willfully defrauding a customer, the fine starts at $1,000 and can lead to revocation of the license. Falsification or forgery of tax documents starts at a $1,000 fine and can lead to dealer license revocation. And the federal fines for this could be much more. So be advised, we are just looking at the state sanctions here, which would be in addition to any federal penalties as well. So it could be extremely expensive. Let's look at some more here. Misrepresenting mileage starts at $2,000 and leads to revocation. Federal penalties could also lead to prison time for odometer crimes. Filing false VIT statements start at $1,000 and can lead to revocation. Let's look at some more violations here. Allowing someone to use your GDN. Allowing someone to use your dealer's license carries fines of $500 to $4,000. You can never let an unlicensed person act as a dealer with your dealer's license or your dealer license number. Take a look at this one towards the bottom. Acting as a manufacturer or distributor will lead to fines that start at $5,000 and can lead to charges being filed by the Texas Attorney General's office. So these are some very, very serious violations. Take a look at a couple more here. Violation of the blue law can lead to fines of up to $2,000. Selling or leasing a vehicle that does not meet emissions can lead to fines of up to $4,000. Overcharging documentary fees can lead to fines of up to $2,000. And we're going to show you how to comply with the documentary fee laws later on in the course, so you will never, hopefully, overcharge. If you follow every rule, law, and guideline required for your business, you will never pay any fines, and you will always keep your license. Remember, 100% compliance equals 100% profits. Next, I want to tell you about the Texas Department of Motor Vehicles Enforcement Division. Texas laws are enforced by the Texas Department of Motor Vehicles Enforcement Division, and they receive about 12,000 complaints every year. They investigate lemon law violations, and they also respond to dealer complaints. So they do dealer enforcement. The Enforcement Division receives approximately 12,000 complaints per year. Enforcement investigators make contact with the licensees and complainants to collect information based on the complaints that are received. The investigators also assist law enforcement by training officers and other agents on rules and regulations to apply to licensees. The Enforcement Division is made up of 5 sections under the direction of a single director who reports to the Texas Department of Motor Vehicles Executive Director. The 5 sections are administrative, legal, lemon law, motor vehicle investigations, and motor carrier investigations. The legal section employs attorneys that review investigations and, if needed, prosecute violations. Administration supports the other section of the functions of human resources, purchasing, and accounting. The lemon law section administers the Texas lemon law and warranty compliance programs that mainly affects franchise dealers that sell brand new vehicles. Motor vehicle investigations and motor carrier investigations are carried out as well. Dealer complaints. I want you to know how easy it is for your customers to make a complaint against you. The Texas Department of Motor Vehicles makes it very easy to log a complaint against any Texas motor vehicle dealer. And they have several phone numbers, email addresses, and an online dealer complaint form that you can see right here. So as you can see, the Texas Department of Motor Vehicles makes it very, very easy for customers to log a complaint against your dealership. So we don't want a lot of complaints being registered against our dealership. We don't want 50 customers a week complaining about our dealership to the Department of Motor Vehicles. You want to try and do everything you can to keep your customers happy, because the Department of Motor Vehicles does make it extremely easy to make complaints against your dealership.